Our top story again now, another day of mainly back and forth in court proceedings between advocates representing 5 suspects in the Meyiwa Murder Trial. We also witnessed heated debate between the presiding judge and advocate Madisela yet again. Just to help us unpack the latest coming out of court, attorney Zola Majavu of Majavu Incorporated joins us now live to give us more details about what he thought in terms of what happened today. Mr. Majavu, thank you very much for your time. Now, a lot of the times the advocate Madisela has been told that he's not following the proper processes when it comes to the Criminal Procedure Act in terms of handing in evidence. I mean, what we've heard him say today is, new evidence that he could have actually had a chance to cross-examine a witness about. Am I correct?
Good afternoon and thanks for having me. Perhaps let me foreshadow my response by saying the following quickly. In lawfare, decorum, deportment, respect for the court and respect for colleagues is very key. It's as basic as that. And what we are seeing unfolding doesn't come anywhere close to that. A short answer to your question is that there is no doubt that my learned friend is definitely not following any well-known and established procedure. And in my respectful view, he is being given way too much latitude. And the sad part is this is going to cause delays that are going to prejudice his own clients who are in custody. So there is no doubt that he need not be reminded by the judge or his fellow colleagues that he is raising points, some good as maybe he thinks, but he is doing so at the most inopportune of moments during the established trial proceedings. So definitely he is following the incorrect procedure. Remember, the matter stood down to today to allow all of them to contact their respective clients, to be in contact with one another, and also to be in contact with the trial roll call coordinator, because days of this nature are not just there for the taking in a busy division such as this one. What ought to have happened, this matter in my view ought not to have lasted for more than 20 minutes, because all they had to do was to tally the dates, agree a timetable, and to make sure that on the next occasion that they would have agreed upon, Advocate Mshololo continues and finishes her cross-examination. She is still on her feet. And that is the sad part about the process that my learned friend is seeking to introduce to the court. And the judge, rightly so, is having none of it. But again, he is being given way too much latitude. But judges are exactly that, they give you a hearing. But I think he is demonstrating a fair amount of disrespect to his colleagues. And it is sad because in our profession, respect is very key. We differ robustly, but we maintain a modicum of respect.
And here and there you'd see he's instructing attorney TT Tobane actually, stepping in to try and basically just douse the situation and make it less, fiery. But also it looks to me, Mr. Majavu, that it's becoming more about egos now instead of the very people that this whole trial was supposed to be about. It seems as though the advocates, in exchanging turns, of course, are forgetting that at the end of the day, this is about finding exactly who killed Senzo Meyiwa to give that family closure.
Well, that's why I foreshadowed my response exactly how I did, to say decorum. At the end of the day, we can differ all the more we want, but we are in a court of law, which is televised to millions. And can you imagine what aspiring law students are having to contend with? This is not a good display. I am for defense attorneys and counsels who fight robustly and vigorously for their clients. And there's nothing wrong with that. But there's a procedure in which you do that. Because while we are busy showboating, the unintended consequences that we are doing injustice to our very own clients who are in custody. The fact that some of them have already been convicted and are serving time is neither here nor there. You are under a duty as an officer of the court to do the best you can to fight for your colleagues. And that duty does not mean recreating new rules of procedure that are unprecedented. Secondly, it is also not correct for both Advocate Tefo as well as his instructing attorney to both be on their feet at the same time. It is elementary. When someone is addressing the court, even if you have the floor, you sit down, you await your turn. Now, it is worse if the instructing attorney as well as counsel are both on their feet. This is making a mockery of our judicial system. And I say this as a colleague. I'm not suggesting that one is perfect, but this is not a good display. And unfortunately, these are the things that cause people to generalize when they deal with all of us as lawyers. And sometimes it leads to an undermining of the public confidence, because people are watching this and saying, what's going on? The judge rightly said, for 2 hours, someone was on his feet and he said nothing.
Yeah.
That cannot be right. And I'm not, throwing shade at anyone. I support my colleagues, all of them, and I have utmost respect for them. But what we are seeing happening in our courts is not going to end well. And unfortunately, if you lose the potential 3 months, a whole term, you run the risk that this matter may not enjoy any preference, and the clients that you are trying to champion their cause are going to sit much longer in custody while awaiting their fate. And it is really sad and unfortunate. I'm hoping that when we resume after lunch, it is going to be about that, setting dates and agreeing timelines so that this matter can proceed. Otherwise, those dates will be allocated to other deserving cases.
And Mr. Majabu, just very lastly from me, in terms of the 2 letters that were handed over by the National Director of Public Prosecutions, saying that docket number 375 has no merit, mentioning a junior advocate that had actually had an internal opinion about who should be charged, but also finding out that docket has had an indictment. Yes, it wasn't signed, but there was an indictment out to prosecute the people who were accused in that docket. Is the explanation by the National Director of Public Prosecutions handed over to the court yesterday, does that explanation suffice?
It doesn't even matter, in my view, whether it suffices or not. Those issues are not currently before this court. The DPP or the NDPP, rightly or wrongly, they decided, as it is within their purview to do so, to prosecute the accused persons before court. If an argument is to be made about those other issues to the extent that they may be relevant, there's a procedure in which those are introduced and entertained. One of the procedures that are available could be, at the appropriate time, you deal with those either in argument or you go into a trial within a trial, if the admissibility of this or that document is called into question. But you do not do that midstream the cross-examination of another colleague who holds instructions from their client after you've had your turn to fully cross-examine without interruption. And that is the point here that one is lamenting. And I think that is where the unfortunate situation in this trial comes about, because issues or documents are introduced without laying a proper basis. Before you tender a document before a court, there's got to be a basis for it. The author thereof must come and talk to it. Alternatively, if you wish to introduce it in the interim, you apply to court to say, court, may I submit this document on a provisional basis on the understanding that the author thereof will come and testify in the fullness of time. And that is admitted into record provisionally. Right. If you do not follow that process, you are going to end up debating side issues. And once Advocate Mshololo finishes, remember Advocate Baloyi still has a right to re-examine the same witness. Witness number 1 that we've been busy with for the past 3 weeks. And that is the point I'm seeking to put across. This trial is not going to be over anytime soon. And sadly, the family of the late Meyiwa will not get anywhere closer to finding the truth. It may well be that wrong people are arraigned in this matter. That's another possibility. I don't know, but the judge must, in the fullness of time, assess all the evidence put properly before him to then make a call. It is not open to anyone to say there is no merit in doing it this way or that way. As lawyers, we are creations of our clients' instructions. Whether they're good or not, as long as you stick within your ethical parallel lines, then you are at large to do whatever it is to protect the law. But that does not mean undermining the court. Does not mean undermining your colleagues. There is neither force nor merit in conducting yourself in a manner that could undermine your very own cause that you are seeking to champion.
All right, Mr. Majabu, thank you so much for your time here on All Angles and for your expertise. Really something that I think Advocate Mshololo has been going with, that it's neither here nor there. Let's just cross-examine and see to it that we subpoena whoever we can if we find that there are grounds to bring those people to court. But let's